Hi everyone, how are we all doing? It's good to see everyone here. Thank you so much for joining us. So I don't know if Kiki is here and if he's ready to start. I'd like to just thank everyone for signing up for the program. Thank you for showing us your lovely faces. You're welcome to Jiipcc Mentorship and Internship Program, and I'm sure that we'll have an amazing time. Well done, everyone.
Good evening, everyone. I want responses if you can hear me.
Yes, good
evening.
Yes, we can hear you.
Good evening, everyone.
Good evening, I can hear you, thank you.
Welcome to the very first session of the third quarter of the Jiipcc internship. My name is Kikela and I'll be your moderator for this session. For the purpose of this gathering, you can address me as Kikela. So this is the intellectual property track of the Jiipcc internship. This is the intellectual property track of the Jiipcc internship. And if you are here, I'm assuming you have at least a little idea of what intangible assets mean and how intellectual property can come in as a regulatory instrument to protect the ownership, distribution, and transfer of rights. So this program seeks to enhance your already acquired knowledge, regardless of how little you have acquired, via mentorship sessions, team projects, and research tasks. As Mrs. Juliana said. So I would like you to put your best into it and take it very serious. So I'll be sharing my screen. Okay, I think someone is doing that already. We're waiting for you.
Please.
I'm actually waiting for him to bring up the photo.
My God. Okay.
Okay. All right, so registration for the fourth quarter of the mentorship session is currently ongoing. You all have access to 30 minutes of private mentorship with the mentors available as you fill in your form. And you're all encouraged to put your videos on so we can see your beautiful faces. And then I would also like you to and every part of this session is being recorded, which you get access to on our YouTube channel. I encourage all mentees to edit the name section on their Zoom account as we'll be taking attendance. So please, if you've not done that, edit the name section on your Zoom account to the name you used to register for this program. So please, everyone should do that if you haven't done that. We don't want nicknames or AKAs or whatever. So the registration for the Jiipcc end of the year party is currently ongoing. It's going to be on as you can see on your screen, it's going to be on the 10th of December on Saturday, Abuja. So you can see the graphics on your screen. All right, moving on to the next. For the mentors we have for today, the first mentor is Mrs. Amusa Shukurat Mudupeola. She's a proficient consultant, an analyst, and an educator in the field of intellectual property with public sector experience. She's a member of the World Intellectual Property Organization Committee, and she has a master's degree in intellectual property from the African University Zimbabwe in conjunction with WIPO and the Japan government. She has partaken in professional training at the World Intellectual Property Organization as well as other IP-related bodies, and has facilitated numerous intellectual property-related programs, both online and offline. Shukrat is the pioneer of an educational platform, TIN, which facilitates IP awareness and brings the knowledge of intellectual property closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and register them for WIPO advanced courses. WIPO is the World Intellectual Property Organization. Amusa is an accredited agent at the Nigerian Intellectual Property Offices, Nigeria Copyright Commission, Trademark, Patent and Design Registry. And the expertise are but not limited to trademark, patent, industrial design, copyright, and trade secrets, respectively. Our second mentor is Victoria C. Onyagbako. She's an astute legal practitioner and intellectual property specialist with experience from reputable full-service law firms within Nigeria and beyond. She's the founder of My Intellectual Property Law Guide, MIPLG. If you use LinkedIn, you probably have come across that if you follow topics on intellectual property, an organization for IP enthusiasts all over Africa. She's an alumnus of WIPO Academy and the first intern of the WIPO Nigeria office. She's an associate member of the Chartered Institute of Arbitrators. She's a member of the WIPO ADR Young. As you come to learn during the course of the program, arbitration is a very key part of intellectual property. She's a prolific writer with notable publications to her credit. She's invested in youth engagement, IP development, and enforcement in Africa. She's currently the Intellectual Property and Human Resource Manager for Innovate of Abuja. Hussein should be sharing that on the screen. So our third mentor for today is Mark Sikongbe. He is the founder, principal of Everlaw Associates. He works extensively in the field of arbitration, ICT technology law, and intellectual property. Max is a facilitator on the annual Information Technology and the law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy and is an accredited agent of the Nigerian Trademark and Patents Registry and has conducted IP registration business there since 2010. So I advise you guys to follow them up on social media, on LinkedIn, on Twitter, wherever you can find them. They are mentors and they've been hired for this program to mentor people. Then, is mentor Victoria on the call already, please?
Yes, please, I am.
All right, please, I would like you to give an introductory speech on the topic. Can you hear me?
Yes, please.
So we'd like you to give an introductory speech on the topic. You have the floor.
Hi, good afternoon. Well, good evening, everyone. Can you hear me?
Yes.
Yes.
Great.
Yes, I hear you.
Thank you. Thank you very much. So yes, and please pardon my voice. I'm a bit under the weather, so I'm doing the best I can right now. So I think it's a very interesting topic, and of course, well done, Juliana, Imam, and the team putting this together. Also, good evening to my fellow mentors. I would want to sincerely appreciate you, Mr. Max, I beg your pardon, and Shukrat. Now, IP for business. I think the best way I can explain IP for business is intellectual property, as I would always say, is a very fluid area of law. And of course, it even goes beyond the law now. And whilst there are a lot of areas that one could specialize in intellectual property law, entertainment and all what's not, business is a very special aspect of it, because with business, you deal with all works, you deal with inventors, you deal with SMEs, you deal with entrepreneurs, you deal with even creators, right? And at the point where everyone is trying to make a living, is trying to, recover money, material gains, of course, from the works that they do and all exploits of life, this comes in very handy. Now, without going into what intellectual property is, I'm sure we all know, I'll give a little basis of what IP rights provide for businesses. Now, in the first place, we would know that it helps to prevent now I'm speaking on a general level, so be it inventors, be it creators, whatever business this person is into, it helps you prevent people from copying your products and, of course, using your innovations. And this is particularly relevant in today's competitive markets, particularly in Nigeria, where you have a lot. We always say Nigeria market is very wide, right? We have a large market. So how do you stand out if you don't protect, if you don't prevent people from copying you or using your innovations? Another thing is creating a strong brand identity. Now, in every market, once you get into this market, a very good way to make something out for yourself is to distinguish yourself, whether in terms of your goods or your services, from those of the other competitors. And how can you do this? Is by creating a brand. How can you create a brand? Intellectual property helps you create a brand, probably through the registration of your trademark, but even beyond that, it could be even merging intellectual property and image rights. Now, as we discuss all of this, you realize that IP would keep cutting across different areas. The third thing is to help you obtain invaluable competitive intelligence. How do you do this? By analyzing commercial and technological information from patents. And this is particularly for those who would find themselves in the technological or innovative space. Now, you could also gain revenues through licensing, franchising, and of course, other IP transactions. How are you able to license if you do not have a legal rights for which you can license? What are you franchising if you do not have a strong trademark which you've distinguished in the markets? Now, another thing is to increase your commercial value. And from the works that I read, I had a good read of the IP for businesses. And you really can't, in this time, move or do with just the tangible properties. So whilst yes, the tangible properties are very important, the intangible assets, where intellectual property comes in, helps you go a long way in terms of creating commercial value for yourself. So you might see for startups in particular, which may not have a lot of tangible assets, you can use your human resource, your manpower, to create more value for your business through the kinds of outputs you make in terms of intellectual properties, right? Another thing is to access new markets. And let's look at it from the point of view of registration. Should you register your work, for example, in just Nigeria, you're leaving room for other people in other jurisdictions to utilize this work if it is not registered in that jurisdiction. But imagine that by registering your work in Nigeria, or by utilizing any of the international registration platforms we have, you are able to access the markets in different countries by being in just one place. Closely connected to that is the franchising, which we've spoken about, and licensing. So you would see that you're in Nigeria, but then you can license your work, whether it is exhaustive or non-exhaustive licensing that you're doing. But someone else in a different country can help push your brand. And you're entering different markets, foreign markets, but you are only able to do that because you have a strong intellectual property portfolio, which can help you enter into these markets. Another thing is engagement in the different types of business partnerships. Now, IP rights provide a basis for collaborative partnerships, which I've mentioned. Example, you'll find this in the research, in the marketing, and then open innovation and outsourcing, etc. I don't see how in recent times, and of course, looking into the future, we'll be able to do a lot of business without partnerships. And how do you do that? Outsourcing. That is one way you can make something out of probably what would seem like nothing for a business. Now, something worth mentioning as well is to ensure the freedom to operate. Owning or licensing in key intellectual property rights can reduce the risk of businesses infringing intellectual property rights of others when using technologies, trademarks, designs, and copyright works, etc., as I've mentioned. Something else is the segment of geographical markets. Now, in some countries, IP owners can prevent goods, protected in their intellectual property rights, which are put on the market from one country or another. So let's say you have a mark or some intellectual property rights which you have secured some geographical protection for. It means that in this geographical area, you've made your mark, you dominate the market there, and in ways that, of course, you do not eventually go against anti-competitive laws, but you're able to, where a monopoly is accepted, utilize your monopoly in the market, in a particular geographical area. And of course, I could go on and on, but in today's world, it's the abundant supply of goods and services in the market have made it very challenging for you to excel if you don't make good use or manage your intellectual property rights. And of course, when we talk about the role that IP plays in businesses, we are aware that it can vary on case-to-case basis and on factors, different factors. So such as, for example, the business model. If you're an entrepreneur yourself, or you're going to be an IP lawyer for a business, that's one thing you should be thinking about. What business model can we adopt as a business or as a company that best suits our intellectual property rights portfolio to help us better utilize our rights? Now, different types of IP rights, of course, will play relevant roles here and there. Some may not, some may not even come into question at all. But it's for you to understand at what point this company needs to project what type of IP rights. What should you rather protect or not protect? Should I use a trade secrets technique, or should I use a patent technique? Should I register this trademark or not? These are some of the considerations that the business has to make. The second consideration you have to take account of is, what is the market? Now, what market is this business venturing into? There are different tools for protecting IP assets, and it will be relevant according to the market condition. So something could be, for example, considering the length, the duration of the rights which you want to protect. So is this a situation that if I registered a patent within 20 years, we would not be able to properly utilize this work, and then it would fall into the public domain? If that is the case, should we rather go on a trade secrets arm so that we can have as much as we can keep it secret and continue to exploit this? Do we do a registration of a design where you would have like 17 years, or that is cumulative maximum, or do we completely ignore it and try something else? So these are all considerations that you would take in this factor now called the market. And of course, the effectiveness and cost of enforcement of these IP rights against competitors. So when you're considering the market, you're also considering your competitors, considering how much it would cost you, how effective is this, and when you put all this together, you're gearing towards utilizing IP for business. Now, the third consideration is, what type of IP does this business use? Now, different types of IP rights, like I mentioned earlier, will play different roles. So for example, trademark protection used to protect the brand, of course. Then you have the patents which you use to protect the technologies, and then you have the designs for the aesthetic value. Sometimes it could be utility models if it is something that is not up to, which does not meet the patent's specifications or requirements. So it's a lot of considerations to take. Sometimes you have more than one IP rights playing out. Most times, actually, you have more than one IP rights playing out. Sometimes you decide to use one, maybe because you've looked at the markets and you think this is just this one that suits the business most. Another thing would be the stage of the business's evolution. Now, the role IP would play in a business would usually become more sophisticated as the business evolves. So it means that for MSMEs, for example, maybe if it would be too expensive for this person to go for an international registration, maybe you're supposed to be looking at having just a national registration and exploiting the work at the national level before you can now move into the international space. Of course, once you've registered in the national, by virtue of the PCT, you've secured what we call a priority date for yourself, so that even when you want to do, or when you want to advance into the international registration, you have a priority date. So what it does is secure the date, the first date which you registered. Now, another thing is awareness in the business. How aware are the managers of this business of intellectual property? How do they see the importance given, or what kind of importance or value is placed on IP and IP rights in this business? It will all depend on how the managers approach it. And it is now your duty as the IP lawyer or as the IP manager to ensure that these people see exactly what they should see in the business. And then I think maybe finally, I probably was spoken a bit more than I thought I would. And then I think I'll finally just, since this is an introduction, touch on the different types of intellectual outputs that are protected in a business and in what way they are protected. Now, generally, we know that the creations of, well, when we say creations, we're talking about copyrights. Now, creations, be it business in the field of literature, arts, books, paintings, whatever it is, copyrights and related rights would cover, or neighboring rights, depending on what you prefer to call it, cover such works. Now, technological inventions, they're typically covered by patents. And in certain countries, such as Nigeria, that now offers utility models, you can also do utility models when your work does not meet patent application. Also in Nigeria, we are also the trademarks, I beg your pardon, the patents registry also does registration of business methods. So that these are all things that you can do in the technological space. Distinctive features in the business. So things like words, symbols, smell, sounds, and of course, always be conscious of the jurisdiction in which this business functions. I forgot to mention that earlier. So you have to always take account what jurisdiction this business functions. If it's an SME based in Nigeria, are there possibilities that this business will export to other neighboring countries, maybe Ghana, maybe the Benin Republic? If yes, should you consider registering that work in those countries where you're likely to export to, or people are likely to buy from? These are considerations. If nothing is going to take them to the US or to Paris, then you might as well just save them costs, and maybe you don't need to consider an international registration in that in these areas. So these are things you should bear in mind. And also things, when I said distinctive features, I mentioned smell, and that was what brought me to jurisdiction. because in certain jurisdictions, smell is not a registrable trademark, while some other jurisdictions have recognized that you can register smell as a trademark. So distinctive features to distinguish their products or service from those of others' trademarks. Now, specific external appearances, as I mentioned earlier, the aesthetics of the products they are bringing into the market. Now we would look at the design rights, right? So in Nigeria, that would also be done by the Patent and Designs Registry. Then again, you look at other things. So for example, closely related to the trademark is geographical indications. Are geographical indications registrable in this area, and how, if yes, should they consider applying for a geographical indication? Other considerations could be trade secrets. Yeah, so look at the legislation. Does this jurisdiction recognize trade secrets? If yes, what does this business need to do to best utilize this? Of course, the other areas emerging, the plants, varieties, these are things that the business could also benefit from. Well, there are other areas such as the integrated circuits, but of course, Nigeria is still coming up or catching up to all of this. So again, it would depend on the jurisdiction. And then finally, as I mentioned again, different aspects of a product are often simultaneously protected by more than one type of intellectual property rights. And after all this is done, you realize that what you've done is to create an IP portfolio for this business. The IP portfolio is basically all the rights or the intellectual property rights that this business owns, be it by way of ownership or licensing or franchising. Every intellectual property right that this business has is what you can put under a portfolio, and then you can start talking about intellectual property management of these rights. So I would once again just say well done, and I'm sorry if I have spoken a bit more than I should. Thank you for having me this evening. Thank you.
Thank you, Ma. You're welcome, Ma. Thank you, Ma.
Thank you very much, Mrs. Victoria.
Thank you very much. That's very insightful.
Thank you.
Thank you, Ma. Thank you very much, Ma.
So if you haven't corrected your name yet, this is the time to do that. I want to see your name, your first name and your surname, the way you registered for this program, because attendance is being taken. And also love everyone to switch on their videos so we can see your beautiful faces. So reiterating what Mrs. Victoria said, IP brings in a diverse dynamic to the business of intangible assets, basically, via licensing and franchising. So using music streaming platforms as an example, Spotify, Boomplay, music makers need to transfer the distribution rights of their asset to other businesses so they can earn even more from streaming. So is the presenter for group 1 on the call? The presenter for group 1?
Yes, I'm here.
All right, so share your screen, please, and present.
All right.
Are you doing that already? Share access to your slide.
Can we see it?
Yes, we can.
All right. Am I to begin presenting?
You can start presenting now. You have 8 minutes.
A minute.
I said 8.
Okay, thank you very much. Okay, good evening, everyone. My name is Precious Esiri. I'm the presenter for Group 1, and I'll be taking us through intellectual property for businesses, particularly centered on patent and trademark. Now, first of all, what exactly is patent? Now, according to the Black's Law Dictionary, a patent is a legal document which provides protection to the ideas of any individual. Also, according to Brownwin H. Hall, A patent is the legal right of an inventor to exclude others from making or using a particular invention. Now, from the two definitions, we can see that a patent is a legal right that is conferred on an individual in order to protect the invention or ideas of such individual, and is a right that excludes all others from making use of such invention for their own benefit. Now, in Nigeria currently, the legislative framework governing the use of patents is the Patents and Designs Act 1970. And according to the Act, the right patent is an intellectual property right, and it is viewed as such because it's an incentive for innovation. Now, moving on to trademark. What exactly is trademark? A trademark is a type of intellectual property consisting of a recognizable sign, design, or expression that identifies products or services from a particular source and distinguishes them from others. Now, a trademark owner can be an individual, it can be a business organization, or any legal entity. It may be located on a package, a label, or even on the product itself. Now, trademarks used to identify services are known as service marks. So instead of the term trademarks, they are called service marks. And the laws currently governing trademark in Nigeria are the Trademarks Act and the Trademark Regulations 1990. Now, the Trademarks Act has given a beautiful definition for trademark, but because of time, we'll not be taking that. Now, there are two symbols that are used to indicate trademarks. The first we can see on the screen here is in the form of two letters, TM, and the second being a letter R encapsulated in a circle. Now, the second is known as the registered trademark symbol, and it is simply used to indicate persons who have registered their trademarks, while the first one is just for persons who have trademarks. Now, the essential function of a trademark is to exclusively identify the source or origin of products or services. That is to say that it is used to distinguish a person's brand from another. So, for instance, if you were to see the symbol of Coca-Cola, you know that, okay, this is Coca-Cola, this is the company Coca-Cola, and this is the products that they are selling. So it is used to distinguish a particular brand from another brand. Now, there are certain exclusive rights that are attached to registering one's trademark. And the most essential being that it is used to protect one's identity and the goodwill associated with their name. Now, back to patents. Why exactly should businesses or persons register their patents? Now, the first mentor, Mrs. Victoria, has given beautiful reasons why businesses or persons should register their patent, but only explain two. The first being that the registration of a patent invention gives the owner monopoly over his invention. That is to say that he can do and undo with his invention. He can decide to keep it, he can decide to destroy it, he can decide to throw it away. So whatever he decides to do with it, he can do so long as he has registered that particular invention on that patent. The second being that registration of a patent gives the person the right to bring up a claim in court against infringement or unauthorized use by persons. So where a person has registered their patent, that person now has the right to come to court and be like, okay, well, my invention without my permission and I want to sue him. It will be a different case if he did not register his patent at all. Because in that case, his patent is not recognized by law that, okay, this is your invention. Or rather, his invention is recognized by law that, okay, this is actually your invention. So registration of a patent gives the person the right to bring up a claim in court in case of an infringement. Moving on to the next slide, I'll be giving two examples. The first example being a business that gained revenue from the registration of its patent, and the second one being a person that lost revenue due to his inability to register his patent. Now, the first example, we have IBM. Now, IBM licensed thousands of technology patents and is now gaining $1 billion a year, just due to the fact that the company registered its patent. Now, an example of a person who didn't register his patent is John Walker, a British chemist who invented matches in the year 1824, the matches that we're all using today, that billions of people are using to cook their food. John Walker invented matches. However, he refused to patent in his invention, and that led to him losing billions of dollars without even getting a dime from his invention. Moving on to the next slide on why persons need to register their trademarks. And there are beautiful reasons why persons need to register their trademarks. The most essential being, like I said earlier, to protect the brand of your business against unauthorized use by third parties. And this is very self-explanatory. This is to ensure that trademarks essentially are used to ensure that persons do not infringe, or rather do not use your product and say that, okay, this is their own product, and then use it for their own benefits. So it protects your brand from unauthorized use. The second benefit being that trademarks serve as an effective communication tool. That is to say that they can be used to effectively, you can use them to effectively utilize the internet and social media. That is to say that when you're advertising your products, persons that you're advertising to can easily relate that, okay, this is who this brand is. This is what they stand for. These are the services that they are bringing for us. For instance, like I had used Coca-Cola as an example earlier. If you were to see Coca-Cola on Instagram, for instance, you know, okay, this is Coca-Cola and this is what they are selling to us. So trademarks can be used as an effective communication tool. Now, I'll also be citing two examples of persons and businesses that failed, first of all, that ensured that they registered their trademark and gained lots of revenue from it, and a person that lost revenue because they didn't register their trademark. The first example is Google. Now, Google is the most valuable trademark on the planet at $44 billion due to what? The fact that Google had registered its trademark. Now, an example of a person that lost revenue because he didn't register his trademark is Charles C. Berger of Otis Elevator Co. in 1900, who coined the word escalator for the first time. But due to his inability to register his trademark over that word, he lost lots of money, billions of dollars in revenue, because he wasn't able to register his trademark. So in conclusion, the world is becoming a global marketplace, and with the rise in technology, businesses and individuals need to register their intellectual property to remain relevant in an ever-competitive business environment. So in order to preserve your business and company, your intellectual property must be safeguarded and registered because it is a valuable asset in our world. So if you want time and effort developing ideas, technologies, and designs that set you apart from other competitors or businesses, then the need to register your intellectual property cannot be overemphasized or underemphasized. So it will ensure that your intellectual property is properly safeguarded and utilized to its full potential. Thank you all very much for listening.
Wow, thank you so much.
Thank
This
you
is
so much.
beautiful.
Thank you
For
very
the
much.
presentation. Thank you.
That was really nice.
Thank you very much.
Thank
The
you.
entire one. You guys did.
Hi, sir. How are you? I'm okay, thank you.
For group four. You can go on, share your slide with us. Godwin Amos, Ife, can you hear me?
Yes, I can hear you. So, good evening, everyone. My name is Godwin Amos, and I'm here to deliver a presentation prepared by Group 2 on the topic Copyright and Industrial Design. Next slide, please. So what is copyright? Copyright is an exclusive right that is automatically vested on someone who creates an original work of authorship to reproduce a work, to prepare derivative works, to distribute copies of the work, or to perform and display the work publicly. So in essence, what copyright does is that it seeks to prevent unauthorized third-party use of a creative work, and it protects the works of authors, artists, songwriters, and other creatives. Next slide, please. So generally, the works that are eligible for copyright are literary works, musical works, artistic works, cinematograph films, sound recordings, and broadcasts. Next slide, please. So moving on to the protection of copyrighted works. So there are generally two types of protected rights under copyright, and they are economic rights and moral rights. So economic rights, they allow the rights owners to make money off of their work. An example of these rights would be the right to distribute copies of your work or the rights to public performance of your work. While moral rights, on the other hand, they allow authors and creators to take certain actions to preserve and protect their link with their work. An example would be the right to be identified as the author of the work, or the right to oppose changes to the work that could harm the creator's reputation. Next slide, please. So to a case where a business person gained revenue from his copyrighted work, an example can be found in the case of Williams and Bridgeport Music Incorporated. So in that case, Marvin Gaye wrote and composed a song called Got to Give It Up in 1976. Later on, he copyrighted the song with the US Copyright Office. So in 2013, Robin Thicke, Pharrell Williams, and Clifford Harris, they released a song called Blurred Lines. So this suit came about because there were complaints that parts of the song Blurred Lines sounded identical as that of Marvin Gaye's song from 1976. So Robin Thicke and 3 others, they were found liable for the infringement of the copyrighted song of Marvin Gaye. So not only was the estate of Marvin Gaye awarded damages as a result of the infringement, it was also held that the estate was entitled to 50% of the ongoing music publishing revenue. Next slide, please. So moving on to where a business person lost revenue from the creative work due to lack of proper protection. I'm sure we all must have seen the movie The Lion King and heard The Lion Sleeps Tonight, which is a popular song from that movie. So Solomon Linda, who was a songwriter and performing artist, in 1938, he composed a song called Umbubi. And it was from that Umbubi that The Lion Sleeps Tonight was adapted from. So he copyrighted the song, and a short while later, he assigned and transferred his rights under that song to a record company for a nominal sum of money. So in 2000, an article published by the Rolling Stone magazine titled In the Jungle talked about how songs that were derived from Solomon Linda's Umbubi were making a lot of money, while Solomon Linda, who was the original author, he practically died a pauper, and his descendants were living in poverty in Soweto. So due to the lack of proper protection, Solomon Linda was unable to earn as much as he should have from his song, and he died in 1962 with virtually no assets. Next slide, please. So we're moving on to industrial design now. So what is industrial design? Industrial design is an aspect of intellectual property which focuses on the appearance of a product, resulting from features such as the lines of a product, the colors of the product, or its ornamentation. So to a practical illustration of what industrial design is, let's say I have a company and my company specializes in the production of bottles. Now, once I have registered the design of my bottle, and the design of my bottle could be the shape of my bottle or the lines that are present in my bottle, or even the colors that are present in my bottle. So once I've registered those, industrial design seeks to prevent third parties from making, selling, or even importing articles that has a design which I have already registered. Next slide, please. So this slide basically shows how industrial design works. So Coca-Cola and Pepsi, they are 2 drink-making companies. They produce soft drinks. So industrial design is not concerned about the drinks that they produce. Rather, it is focused on the appearance or on the products that these 2 companies are used in selling their drinks, which in this case would be the shape of the bottle that they are using to sell their drinks. So industrial design seeks to prevent Coca-Cola from registering the design of the bottle that Pepsi-Cola is using, and it seeks to prevent Pepsi-Cola from registering the same bottle that Coca-Cola is using. Next slide, please. So why do businesses need to register their industrial design? A reason would be that it provides exclusive rights. So protecting industrial designs is essential to enable one prevent unauthorized imitation of designs by third parties. Industrial design also generates revenue in the sense that the rights can be sold or licensed to another business, which would then generate revenues for the rights owner. Industrial design also encourages creativity in manufacturing and industrial sectors, which in turn leads to an expansion in commercial activities. Next slide, please. Now to a business that registered its industrial design and gained revenue. So we're going to be using Procter & Gamble, for example. So it is the world's largest, next slide, sorry. So Procter & Gamble is the world's largest consumer products company. In 2011, it topped the list of applicants that are using the WIPO's EIG system for international registration of industrial designs. So the WIPO magazine interviewed the director who was in charge of P&G's design. He stated that P&G developed their designs using design thinking sessions, and they developed their designs using consumer insights. So he stated that design plays a key role in the success of P&G's extensive product range, which includes some of the world's best-known household brands, 25 of which generates over $1 billion in annual sales. So what industrial design does for P&G is that they create new products, they register the design of their products, and since they have exclusive rights over that design, they make a lot of money from registering that design. Next slide, please. So now moving on to business that did not register its industrial design and lost revenue. So we're going to be looking at the case of Original Beauty Technology Limited and G4K Fashion Limited and others. So in that case, the House of CB brought a claim against Opoly for infringement of their UK and EU unregistered design rights in relation to 91 items of clothing. So 20 out of those 91 items were used as a sample to assess for infringement purposes. So evidence from that case showed that the defendants had collected images of the claimant's clothing and then sent them to a factory to be copied. So the High Court awarded £450,000 in damages to the claimant. Next slide, please. So the £450,000 awarded, it did not cover the amount of sales lost, and it led to loss of revenue on the part of the claimant. Next slide. So in conclusion, if industrial designs are not protected, there are no exclusive rights over them, and therefore competitors could put an identical or a very similar product on the market without having to ask for authorization. What this means is that if a competitor, a third party manufactures or third party sells or even imports products that incorporate a design, in most cases, no legal claim can be made if that design is not registered. So we have come to the end of this presentation.
Thank you very much, Godwin Amos Ife. Really enjoyed your presentation. It was beautiful.
Good job, Godwin.
Is the presenter for
Great
group 3.
presentation. Thank you so much.
Is the presenter for group 3 on the call? Group 3. Group 3. Are the group 3 members? Yeah, please. Who's the group leader? You say something.
Hello, sir. She's not around. She's not around. She kind of
Who's your
did
backup presenter?
responsibility. The person presenting is Michael. I believe he's on this call.
Okay, so why is he not responding? So who's the backup presenter if he's not presenting? Do you have a backup presenter? Okay, if he's not responding,
Yes, we do. Yes, we do. We have Annette. I can't pronounce it on, but she's. I think I saw her earlier on the call. Let me check group name.
Right. While we sort that out, presenter for group 4, please. Group 4 can continue. Who's the presenter for group 4? You can go ahead before group 3 gets ready. So group leader for group 4, contact your presenter, please.
Okay, sir.
Is group 4 not available also?
I'm trying to contact Richard Ujob. He's the one presenting for group 4.
Oh, so both group 3 and group 4.
And he's actually on the call. I don't know why he's not responding.
Is he having stage fright or something? Richard, please respond. We're waiting for you. And also the presenter for we're waiting for you. Okay, your voice is breaking, Richard. We can't hear you clearly. Richard, can you hear me? If you can hear me, we can't hear you clearly.
Yes, I can hear you.
All right.
I can hear you.
Who's sharing the screen? Whoever's sharing the screen should share the screen.
Victoria.
Please, can we make it quick, please?
Victoria, you're also on the call. Can you please share the screen
Don't want
so
to
Richard can
keep
present?
mentors
Yes,
waiting.
I'm working on doing that now.
All right, thank you.
If she's not able to do it from her end, someone else can try.
Thank you, somebody for sharing the screen.
Okay, we can see your screen now. Richard, are you still there? Okay, I think Richard is no longer on the call. Group.
Okay.
Who's the backup presenter?
The backup presenter, Prince
He's no longer on the
Chibuzo
call.
is on the call.
The backup presenter should present for him, please. He's no longer on the call.
I am on.
All right, please, thank you.
Okay.
Go ahead.
Give me some time. Let me address some issues here. Okay. All right. Okay, so hello, can you see my screen? Hello?
Yes, we can see your screen.
We can see.
Okay. All right, so good evening, everyone.
Okay.
I am Prince Chibuzo, and representing Group 4. And my discourse is on IP management for business. Okay. So first of all, you must understand that IP management is a system that helps manage tangible products, such as the mind's intellect, such as our question of the mind, our imagination, our concepts, our designs, our thoughts, the thoughts that are put into actions. And like we all know, man is the creative being, and there's a need for us to protect this creativity of man, for it to be utilized for the creator of these things. And the whole system, the whole framework that governs a person, a business, a company's products and IP is known as IP management. So various corporations, various companies employ this method as a system to track their assets, the IP records, and their IP management systems in a company. So that is it for that. So going to the next slide. Okay. Now a good IP management have some basic features. Yeah, some basic features that you must find in every IP management system. One, we have regular audits. Now, what this means is this: each IP management should be audited on a regular basis. It could be monthly, it could be annually, or preferably weekly. Because the fact is this: as companies become more strategic, as companies become more complex, their IP also grows. So there should be an auditing system to audit their management. So we have team education. And what it means is this: the team that manages not just on the IP, effectively manage an IP without understanding the business of that IP. So the team must be educated on that. And thirdly, we have regulatory compliance. Yes, that's very, very important. The patent, the copyright designs, and what's of copyright, patent, and design should be in line with the relevant regulations and relevant laws. And it should have a detailed record. It should have a detailed record. Highly organized information and data visualization is critical to possess the following skills for effective strategic portfolio management. And that is prosecution skills, litigation skills, license negotiation skills, IP evaluation skills, and portfolio management skills. Now, a good IP rights management should involve and include both an analysis of competitors and an analysis of risk, and take into account the company's long-term and short-term commercial objectives. We go to the next slide. The benefit of IP management. First of all, the basic benefit is this: it helps a company, it helps a business, it helps any organization whatsoever, even an individual, such as a star to public figure. It helps any person that have an IP management to be informed about his rights, about where he has a right in his IP. All right. And secondly, it also informs the general public and general population about what is IP. I believe that when there is an effective IP management system, the person or the company or the organization would understand that there is a right that he has in the position of an IP. And two, it recognizes, monitor, and documents IP ownership and rights. Yes. So when there is an effective IP management system, it recognizes, monitor, and documents the ownership and the rights that a business has over an IP. And thirdly, it addresses patent portfolios issues. It addresses infringement behavior. It addresses theft and other incorrect application. So supposing there is a conflict in terms of infringements, when there's an effective IP management system, all these issues will be swiftly addressed, because there's always a backup and a management that governs the IP of the company or the individual. And it also developed a viable non-disclosure policy. Yes, non-disclosure policy, such as trade secrets and the likes. So when a company, a corporate organization has an effective IP system, okay, it's helped the company to understand its trade secrets and also to develop a very non-disclosure policies that govern those trade secrets. And it also aids in keeping track of insensitive violation and lawsuits filed by competitors. And furthermore, it provides the paperwork for license agreements and related contracts, as well as enable businesses to control post-insurance procedures. Now, an example of business that have managed its IP so far from time is Apple. Apple has made various innovations, various strategic development within that IP, and they have a way to govern and protect the use of that IP. And from the image above here, we could see how Apple have been strategic enough to, and we see in all their products, they have their logo, their IP, their design is always there. Their design is always there. And over the years, we've seen how they've progressed from their phones, their laptop, their earpiece, their charger, and we see how it protects them. I believe so far, so good. I think Apple phones, that is Apple's phones, is the only phone that cannot be imitated by other companies. Unlike Nokia other phones, you could see that there could be some imitation or slight imitation from other companies. However, Apple is just strategic. It's just the only one that has a very defined and definitive industrial design. So furthermore, IP assessments and definitions. Okay, an IP assessment definition is the process of evaluating the monetary value of IP assets. IP valuation also helps to determine the true value of the business and capitalize on assets that may not have been aware of in possessing. In order to be able to sell, license, and enter into any commercial agreement based on IP, you must know the value on an IP asset. IP valuation is also beneficial in the enforcement of IP rights, for internal management of IP assets, and for various financial processes. Now, IP assessment also allows enterprises to determine whether their IP is reasonably protected and whether it currently provides a competitive advantage or may be used to gain a competitive advantage in the future. An IP asset steadily grows and they should be effectively utilized. Okay, when IP assets are accumulated, it could be an armor that protects the enterprise from other market competitors, as well as a powerful tool to initiate attacks and defend its business trade and secrets. So what this means is this assessment.
Sorry to cut you short, Prince, but try to make it snappy. You spent over 8 minutes.
Okay. So basically, what this means is this: an IP assessment and valuation system it helps to evaluate the process of monetizing our IP assets. Also, basically, it helps us to understand our values in our IP and how we can use it in the market. So that's it for IP asset definition. Okay, now the value of an IP asset is derived from, okay, now there are two approaches to typically use to value an IP property, an IP. One, we have the income method and the market method. All right, the IP valuation is based on future projected cash flow related to an IP. That is the income method. It's based on the future projected cash flow. And the market method is based on observations of actual third-party transactions of comparable IP to determine a market price. And establishing the value of IP is critical to determining sales, licensing, and pricing of IP assets, and for merger and acquisition transaction. Okay, so the governing regulations on IP. Okay, the benefit of IP assessment and valuation is one, it helps to use appropriate and trustworthy information and market forecasts to determine future investments. It helps to give it a value calculation of the patent, trademark, and copyrights of the company in an issue of licensing or third-party application. And it gives firms the legal and transferable proof of ownership, so their most intangible assets. An example of this is Google. Google is one of the most used search engines in the world. And according to research, Google trademark is now the most valuable trademark in the planet. That's according to Brand Finance. It is worth over $44 billion. So that's one of the companies that have effectively used its IP assessments in the world today. So next slide, please. So we could see examples of people and how they've used it. Okay, now we have furthermore, we have trade secrets. Now, trade secrets are distinct from patents in that these are formulas, practices, processes, patterns, and informations that have attained to inherent economic value by not being generally known. Okay, now an IP a trade secret is basically informations, formulas, tricks, processes, practices, designs, patterns, way of doing things, modus operandi that are kept secrets, and they are kept inherent only to the preview of only those who have access to it, and they are very, very secret to the extent that it cannot be disclosed to anyone outside the preview of those who are meant to know about it. Now, for anything at all to qualify as a trade secret, it must be commercially valuable. Yes. And also it must be strictly known to a limited group of persons. That is one. And finally, it must be subject to reasonable steps taken by a rightful owner of the information to keep it secret. So these are the qualifications for an idea or an information in practice to be known as a trade secret. Okay, so next slide, please. So okay, so benefit of trade secrets, it protects against a company against unfair competition. It prevents information that could be used against the company from. So it prevents a company. It prevents information to be used against a company. Okay, it enables a company to maintain its advantage in the competitive market. So an example of a company is the Coca-Cola company that since 1886, it has been able to keep its trade secrets as a very viable essential product. Of course, we've had these rumors in time past of Pepsi and other drinks company, soft drink company trying to get the secrets of Coca-Cola, but it has been abortive because they've been able to keep their secrets safe. And according to research, it is currently in a bank vault in Atlanta, where no one can get it except the founders of the company. So the last
Prince, please wrap it up. We don't want to keep the mentors waiting, and you spent way more than you should have. So please just wrap it up. Thank you.
Yeah, I done already. I think I done already. You're done with the presentation.
All right. Thank you very much, Group 4. Thank you very much. You really put in a lot of effort into your work. Group 3, the presenter for Group 3.
Yes, sir. Good evening.
Good evening. Good evening. So
I'm
share
here.
your slide.
All right. The person sharing slide is okay. Good evening, everybody. My name is Echeme Robert Carlo. I'll be presenting for Group 3. This is the Jiipcc Intellectual Property for Business presentation for Group 3. So our topic would be on franchising, licensing, and exploitation in intellectual property. We'll be looking at the legal implications of this concept, and then we'll be, looking at instances or examples where franchising, licensing, and exploitation in intellectual property applies. Now, as a preamble, as a preface, it's basic understanding that intellectual property is a territorial right and it's exclusive only to the owners or to the people that are granted access by the owners. Now, the implications of it being exclusive, the implication of it being territorial, first of all, is that only the owner can access it and can have a certain degree of control as to who has access to it. The implication of it being territorial is that it is only operational within the country where the IP intellectual property right is registered. Now, we also had issues to consider. Does this absolutely prevent third-party access or usage of another person's property? That's if you're looking at it from the perspective of exclusivity. Is this to say that intellectual property is strictly domesticated? Now, going forward, we are going to answer these questions in looking like by examining this concept that we are to explain. We are going to, address these questions. Now, what is intellectual property franchise? Now, the definition we provided as group, intellectual property franchising, the transaction which allows for a franchisor and a franchisee to enter into a franchise agreement such that the franchisor allows the franchisee a certain amount of control over how they can make use of their intellectual property in exchange or in return for a fee or a royalty. Now, an example that we cited here is Kentucky Fried Chicken out in Nigeria. Now, some of us that live in Lagos, but some of us that live in Lagos, we are quite familiar with the Kentucky Fried Chicken brand. It's actually an American-based brand. Now, upon its creation, the owner didn't just hold the intellectual rights to himself. He decided to grant other people access so that the outlet can be made available in other countries. That's why he decided to franchise his company. Now, today I'm actually standing. Funny enough, I'm actually standing in front of the Market Square store, and this is also an example of how intellectual franchising can apply in real life. Now, what are the benefits? What are the consequences of franchising intellectual property? Now, we looked at these benefits from the angle of what franchisor stands to gain or what he stands to lose, and what the franchisee stands to gain and lose. Now, looking at the points we've addressed here, we said business under benefits for the franchisor. It says business. We have business expansion. Now, for the franchisor has the capacity to expand his business. Now, taking a look at Kentucky Fried Chicken, popular KFC, it was once an American outlet, but now it has expanded. Now, passive income through payments by virtue of the fact that the franchisee makes payments to the franchisor, the franchisor is able to make passive income because he's not actively involved in operating this business now. He has given over access or control, but not ownership. That's something we should note. He has given over control to the franchisee to run the business for him, and the regulation or control of IP. Even though the access has been granted to the franchisor has to an extent can control how the business is operated. Now, for the franchisee, the benefits that accrue to the franchisee include pre-established business model. Now, the franchisee doesn't have to reinvent the wheel. The franchisee can start off from where the franchisor started off. He doesn't have to come up with new ideas, although he can suggest new ideas, but he already has a pre-established plan to work with. Furthermore, we have regular upskilling or training. Now, franchise agreements usually afford franchisee the opportunity to be trained or to be educated one way or the other, because the franchisor doesn't want their brand to fail in public eye. They want to boost their brand, and to do that, they have to train their franchisees so that the franchisees are able to keep up the good repute and the good name. Now, following up, we have less risk and we have deep relationship between the franchisor and the franchisee. Now, these two are self-explanatory. Following, like the risk aspect is a follow-up from initial points I discussed on upskilling and training, because if you're being trained, then the risk that it stands to have in the course of operating the business is lower. Deep relationship, in the sense that when you're entering into a franchise agreement, you have to maintain the connection with the franchisor as a franchisee. Now, the consequences that come, we have risk of violation. Now, it's possible that the franchisee can go beyond their contractual agreement. From the perspective of the franchisee, we have cost intensive. It's cost intensive for them to make payments. Usually the fees and the royalties that they have to pay is usually high. We have it's complex, and there are stringent rules and obligations. Usually, the franchisor will impose obligations and strict rules governing how they want their business to be operated. Although it's not within their own care to operate these businesses, but they still own it. So, like they still have like a regulatory hand how the business is run. And then stifled creativity. Although this person might be, although the franchisee might be bubbling with ideas, the franchisee cannot take action on his own. He's only advised at best. He cannot take action on his own. So all he has to do is advise, and it's left for the franchisor to either adopt the ideas or to decline the ideas. Now, moving forward, we'll be looking at the factors to consider before and after acceding to a franchise agreement. Now, distinguishing factor of the organization from our competitors. Now, you have to look at the background. How popular is this brand from the what do you call it? From the perspective of consumers? How high do they rate this brand? What's the rating of this brand? For instance, now Kentucky Fried Chicken, people actually have a high rating for Kentucky Fried Chicken because people usually patronize it. Even their advertisements, their publicity is very nice. That's something that franchisee should look into. He should make his research into, and then he should look at successes recorded by the franchisor. Now, if you're going to enter into a franchise agreement, you're not going to enter into a franchise agreement with a company that is incurring losses, but you should ensure that you're entering into a franchise agreement a promising company, so a company that is not in the doldrums, but going to that is making income, and it has potential in fact. And then going forward, you have to consider the content of the franchise agreement. This is like normal contract principle that before you sign an agreement, you have to read. So essentially, when you're going to bid, you should understand, okay, what are the obligations that apply? What are the rules that I'm being governed by as a franchisee? Can I as a franchisee take decisions on my own, or am I tied to the constraints of the franchise? So all these things factor in when you're going to enter into franchise agreement. Moving forward, you have intellectual property license. Now, intellectual property license is similar to IP franchise, but now it's a little more. It's a little bit simpler because here the licensor, in this case, not franchisor, the licensor and the licensee enter into a license agreement, such that the licensee is at the liberty. Like if you recall what I said initially, you notice that although the franchisee has some sort of control as to how they're going to operate, they don't own the business themselves. But now the licensee has freedom, he has liberty to operate the business as he wants because he himself is the owner. Now, an example we gave here, IP licensing is as it applies to goods and services, is found in section 33 of the Trademark Act. Now, an example we provided here is Disney branded soaps. Now, usually you would find branded items. Let's say when we are growing up, we had Disney bags, we had M&M's wristwatches. These are examples of IP licensed goods because the IP owner, the intellectual property owner, has decided to grant a license to manufacturing companies to produce goods that are branded with their own trademark. I believe that's self-explanatory. Now we are going to go forward and look at the pros and cons, the benefits and the consequences of IP license. Now, we are going to look at it like how we did initially. We're going to look at it from the perspective of the benefits accruing to the franchise, to the licensor, and then benefits accruing to the franchisee, and then the consequences as well. In terms of the benefits, we'll be looking at passive income generation. Like we mentioned earlier, if you're going to sell off your IP rights, you're going to get this is not, you're not doing charity work. You're going to sell off your business, and you're going to make returns or make profit either instrumentally or a down payment for the IP rights you're selling off. Then very clientele based. Now through licensing, it opens you up to like a broad range of clients. For instance, if Disney wants to produce soaps or go into soap production, they can license their trademark to a company. So it opens you up to a wide variety. Coming over to the franchisee, there's less control or interference by the licensor, because the licensor rather. Now the licensee has greater liberty, as I mentioned initially in the introduction. And then we also have opportunity to use well-known brand. Now, as a licensee, you have the opportunity to make use of well-known brand names. For instance, Disney branded goods now. The soap companies or the perfume companies that are producing these goods have the chance to be associated or to have a relationship with these known brand names. Going forward, we'll be drawing comparison between IP licensing and IP franchising. As I mentioned initially in the discussion, I explained that IP licensing and IP franchising have some sort of similarity, but they're not exactly the same. Now, on the first point, we'll be looking at the extent of control or autonomy that the franchisee
Thanks
or
for wrapping up, Robert.
I'm so sorry.
Please take your time.
All right.
Summarizing it, please.
Okay. So looking at the way we considered the differences, we looked at it from the perspective of control and autonomy that the licensee or the franchisee has. We looked at the degree of complexity. How simple are these transactions? How complex are these transactions? Next, we looked at how accessible do the how much access is does licensee have to using trademark and business models of franchisors or franchisees, and then how much creativity is allowed within this franchise license agreement. Going forward, we're looking into IP export. So if you recall from the introduction we made, we asked the question, does it mean that IP intellectual property rights are strictly domesticated? Now, to answer this, we'll be looking at IP intellectual property export. Now, intellectual property export essentially allows you to give your give protection or give recognition to your intellectual property beyond the scope of the country where it's registered. So, like Miss Victoria mentioned initially, she says access to new markets. So it opens up the doors or opens up the window of opportunities for you to have protection for your intellectual property rights in markets or foreign markets that you didn't envision before. That's the essence of intellectual property export. Now, requirements. To summarize it, it's essential for you to actually export your right. You have to look at what the rules in the other country is. So, considering that that's how you're going to have a successful intellectual property exporting. Now, to conclude, we emphasize the fact that all these concepts such as intellectual licensing, intellectual property franchising and exporting are crucial to business operations, and their importance can be overemphasized. For instance, we have looked at the advantages that it provides, the fact that you can gain protection in other countries except the country where you have registered your brand. Thank you very much. I still remain Nana Kalu Echeme from Group 3. Thank you.
Thank you, Robert, for that presentation. So I would like the mentors to give comments on the presentations. Mr. Max, are you on the call?
Yes, I am.
Mr. Max.
Yep. Can you hear me now? Can you hear me?
Yes, I can hear you.
Okay. Thank you. Well done. I think this has been extremely interesting. I must commend all the speakers and of course commend the organizer, Juliana, for putting this together. I can see that the program has actually stepped up a couple of notches. The presentations were really good. I loved at least the PowerPoint presentations. They were really good. And I think the way the topics were approached by each of the speakers was good. So I'll just make quick comments. So group 1 on patents and trademarks in the context of IP for business. Yeah, I heard a few things which I found really interesting and quite quite good, because when it comes to IP for businesses, patents and trademarks actually are some of the two most crucial game changers for businesses when it comes to IP. So invariably, particularly for businesses that are product centered, patents and trademarks are, without patents and trademarks, you'd rarely be able to make any headway for those kinds of businesses. one of the things, of course, the presenter, I believe that was Precious, was mentioning was about people who lost out big by not protecting their IP. So the guy who did matches, the escalator guy as well. Yeah, so it's actually a huge issue. But of course, you need to know that there are some people who may be out of naivety or just out of altruistic motives make up their mind that they are not interested in getting IP protection. Some people just think it is contrary to the spirit of competition and of fairness to monopolize any rights. I mean, of course, sometimes even Elon Musk makes some of those funny comments about not being bothered about getting IP protection for some of his products, or saying he just wants the product to be out there for the benefit of humanity. Now, what I always tell people is that when you say that, actually, you are being, with respect to people who think that way, being naive and foolish. Because if you refuse to protect your IP, someone else can pick your IP, get a protection on it, stop you from using your IP, and end up stopping others from using that IP. So you end up, so far as I'm concerned, 2-0. You have ended up losing your own rights, and then your good motives, which you wanted your invention or your IP product to be of value to all of society, is also lost at the end of the day. So even if you want to be good to society and say, look, I don't want to have a patent because I want everybody to benefit from my invention, it is wiser to register your invention and then try to license it. I mean, there are many frameworks under which you can license to allow them to use it. So for instance, we talk of what we call the Creative Commons or open source licensing. So it's a licensing framework where you say, I'm licensing my work. Anybody can use this work freely. But the only condition is that if you use this work, then you have to also license the work on the same conditions for others. So it means if you pick my work, you use it and you create a new, maybe a better invention out of it or a new product out of it, then you must allow other people also use those products on the same basis. So of course, when it comes to Creative Commons, open source, like I mentioned now, they apply more within the context of copyright. But there are other frameworks for licensing within, for instance, patents, where it is possible to also tinker with and have something close to this kind of arrangement where you are saying, yes, I don't want to gain IP rights because I want everybody to be able to, I don't want to monopolize the rights. I want the, mankind to benefit from my invention or from my IP works. But like I said, even if you are doing for altruistic motives, you should still get your IP protected and then decide to let people use it on licensing terms that are open and fair and that make it available to others to build up on. So then just to make also a comment on the escalator guy. So what happened to the escalator guy? Escalator actually is what we call genericide. Genericide simply means through your inadvertence or through wrong strategy, you have allowed your IP rights to become generic. So particularly this happens in the context of trademarks, because you should know that when it comes to trademarks, you cannot protect as trademarks terms which are generic. So for instance, within the, if you are, for people who sell fruit, agricultural produce, for instance, the term apple will be generic because that's a common terminology within that industry. So no one producer of agricultural produce should be allowed to monopolize the term or trademark the term apple. But however, within the computer industry, apple is not generic because, I mean, it's not common to call computers apple. So that is why Apple, for instance, can have a trademark within the computer industry. So what happened to Escalator is because they did not protect their trademark on time, Escalator became so popular that it became the default way to refer to any any moving staircase that actually takes people up. So Escalator is supposed to have been a trademark, but because they did not protect it or they did not use it in a trademark sense, it became generic. So another word, for instance, that's always stood the risk of becoming generic is Google. Because when a person says, go and search the internet, they use the word Google it. So a person could tell you something like, I tried Googling it on my Bing, on the Bing website, and I didn't get any response. So the same thing, for instance, in common usage, people say something like, Madam, I want you to give me the Dangote Indomie. So, I mean, Dangote has their own noodles. Indomie has own noodles, but because the word Indomie and noodles have almost become synonymous. So people just call every brand of noodles they see Indomie. So it's a danger. And that is why one of the things that as a brand you should do is to always communicate how people should use your brand to avoid it becoming generic. So, I mean, I recently concluded the distribution agreement, and we had to set out a very detailed brand guideline telling our sub-distributors, our distributors and their sub-distributors how you cannot use our brand. So we don't want our brand to become the generic name for goods in that category, and then a time comes where we lose our trademark. So it's also something very important to note that you must be careful how you use your trademark, particularly in the context of licensing or franchising, which I believe Group 3 spoke about. You must be careful to avoid allowing your other third parties who are permitted users of your trademark. You must ensure they use it in a sense that it doesn't become the generic or the common name for goods or services in that category. Otherwise, you stand the risk of losing your ability to protect your trademark in that context. Then Group 2 spoke about copyrights and industrial designs, two also areas of IP that are gaining new relevance. Copyright, because of its relevance in the in the digital space. So copyright has gotten a new lease of life. I mean, before now, copyright was restricted to use within the literary industry and creative industry. But suddenly, technology has given copyright a new lease of life, and copyright has gained new relevance within the context of technology, within the context of IT. So it's also another area that is that is gaining a lot of relevance. So of course, there are some unconventional copyright. So one of them, of course, I've mentioned, which I've hinted, is computer programs. So computer programs are not protected typically under patent law. There's a way you could protect them under patent law if you can show that what you are protecting is a computer implemented invention. Then you could protect it as a patent. But traditionally, computer programs, as the softwares, the computer code written and all, is protected as a copyright. And of course, the reason for that is simple, because when it comes to computer coding, what the coder is doing essentially is expressing his creative flair, not necessarily an inventive step per se. So it's a technical area, but just have it in mind that to get protection for your software, as it were, for patents, then you need to show that it's a computer implemented invention, or the computer implemented invention aspects of that software is what you can protect as patent. But in the event, I always tell people who come to me, because they're always worried, fintech startups and all, they always want patent. And I tell them, copyright is even better for you than patent. Copyright lasts for 75 years after your death. So if you are a young person, you have another 50 years to live, add that to another 75 years. It gives you a longer range of protection than patent. Patent gives you just a 20-year protection, but people just seem to have that preference for patent and worry you and go to great lengths to get you to somehow hook up a patent for them than rely on copyright. But like I said, it's just a funny decision that people make. Then industrial design is also beginning to gain some relevance, because people have realized that industrial designs can be used to protect product packaging. So that has also become another very important. And then we have things like what we call trade dress, which are also new kinds of IP rights. Industrial design plays a significant role in protecting those rights. So that has also made industrial design become more relevant. Unfortunately, in Nigeria, industrial design is still a distant last when it comes to IP rights. I mean, if you go to, I think the last data I saw from the patent, copyright, trademark, patent and designs registry, so that I think in the year 2020, relative to others, I don't think we had up to 400. No, I think it was even way less, maybe 40 or something there about industrial design applications all year long. So it's unfortunately in this part of the world, industrial designs come a distant last. Globally, industrial designs are the least popular amongst at least the 4 primary intellectual property rights. But other places, they have developed greater uses for industrial designs than we have here. But we need to just learn that industrial designs can be an overall part of your, Group 4 talked about the IP management for businesses. So industrial designs can be an overall part of your strategy for your brand protection. You can use an industrial design to kickstart the first phase of protection for your brand packaging. And as the brand packaging becomes very unique and you communicate it over time to the market, it could actually become distinctive enough for you to actually now trademark that as some aspects of that packaging. And the good thing about trademarks is that it could last forever, provided you keep renewing it indefinitely. So it's a wise strategy to start with industrial designs, to give you enough window of time to show evidence that, look, this packaging has become distinctive. Because you, of course, you know that for a trademark, to register a trademark, it has to be distinctive. Distinctive simply means that it must be unique enough to communicate that exclusive source identifier function. So you could use industrial designs to give you the monopoly within the the first 10, 15 years that you need to drive that distinctiveness, and then you could now use trademark to protect your product packaging on an ongoing basis, indefinitely or for as long as you desire. Then of course, one important point I should have mentioned this, both group 1 and group 2, when it comes to patents and industrial designs. Now, novelty is a requirement. That means to be able to patent an invention or to register a unique design, it must be novel. Novel simply means that it has not been disclosed to the general public anywhere in the world. So the fact that you come up with an invention or a new unique design and you begin to go around with it and show people, you lose the right to ever be able to get an industrial design or to ever be able to patent that product. So I keep telling people this is very important that creatives know about this, that the moment you get an invention, you have to keep it secret until the time you get it registered as a patent or an industrial design as applicable to that product. Otherwise, you lose the right forever. You cannot, because the fact that you have started selling the product or making it available to the public means that you have destroyed the novelty of that product, and you can never get industrial design protection or patent protection. So it's actually it's just like genericide I mentioned for trademarks. This is equivalent in the area of patents and designs, that if you disclose, you destroy your novelty, you can never get protection anymore. Then IP for business, I believe I've mentioned a lot of that. So why IP is important for business is that IP is simply is a means to an end, it's not an end in itself. So people only protect their IP because they want the IP to be used as a competitive advantage to help them sell more products or acquire new customers and essentially make more income and profit. So bottom line is that for any business, what they want to see their IP do for them is that bottom line, their profitability has increased because of IP. So not viewing IP from that viewpoint for businesses can be a problem. And what has happened in Africa and in Nigeria particularly is that a lot of IP professionals, particularly I keep accusing my generation of IP practitioners and the old IP practitioners, we only learned IP initially from the dry state of IP itself. Just we knew about trademark, copyright, patent, and all, and would encourage people to register. But we never understood that you need to show business people that it's not just about registering, but show them an overall picture of how protecting your patent, trademark, patent designs, copyright could ultimately lead to increased profitability. So I keep encouraging people in this program, always think of IP from the context of business. Try not to just think about, because a lot of people run around, they have enough knowledge, and they can argue and all of that about trademark and patents and all. But if a client comes to them with a real problem, they are not able to proffer solutions using IP as a tool. So you must always see IP as a means to an end. The end is profitability. So how can we use IP to get to profitability? That should always be your mindset. So always think about IP within the context of industry. Don't think about IP as a standalone. So when you think about trademarks, know that trademarks in the pharmaceutical industry is a different ball game from trademark in the sports industry, from trademark in the technology industry. You need to understand that context. And I encourage people, if you want to start a blog or you want to write about IP after this program, always think of how do I contextualize IP within a particular industry I'm very familiar with, and show that industry how IP makes a difference overall. Then also another important point I'll make about IP that's good for IP for management is that IP management actually is using IP as a sword, as a weapon of offense, as an attacking weapon, rather than as a shield, rather than as defense. Traditional IP is just simply, okay, I register my trademarks, anybody tries to do it, I prevent them from using it. But when you understand IP management, you understand that your IP becomes not just a cost center, you're not just using it as a defensive tool. You're also using it as a tool to expand your business, to increase profitability. So that's where licensing begins to come in and so many other things. So you're able to advise business that, look, it's not just about registering your patents and preventing others from using it. It's about thinking, how can I allow others to use it in a way that we collaborate, that I gain more knowledge, that they are through their use, we're able to gain greater insight into how our products can sell better, and then overall productivity comes from that. Then for the last group, I'll just mention two things on franchising.
Now, thinking of franchising now, particularly in Nigeria, and I believe this applies even in other African countries. Now, one area where there's a tension between IP, where there's a tension for IP, is that there's a tension between IP and competition law. Because IP essentially, okay, let me move back a little bit now. We need to understand that the global system as it stands now is more of a capitalist system, which is based on the principles of, of open market and competition. So because of that, IP right is almost a derogation from competition, because competition simply says, look, everybody go into the market, compete, and let the best product and the best service win. And in the course of that competition, the ultimate good of the end user is protected because competition will make prices come lower. But however, IP right is a derogation, or it's a negation of that principle, because IP right is now allowing producers to create a monopoly for, under limited circumstances that will now, in a sense, impact competition negatively. So you need to always understand that there's that tension between IP law and competition law. Now, in the area of franchising, that conflict already is at boiling point in Nigeria at the moment, and I believe in other countries too, because of the Federal Competition and Consumer Protection Act 2018, which essentially sets up a competition structure in Nigeria. So one of the things that law says is that you cannot grant exclusive distributorship licenses to people. So that becomes an issue, because franchising essentially is essentially at its baseline a grant of exclusive rights to to run a business format in a territory. And now the FCCPC Act says you cannot do that anymore. So it takes a lot of clever engineering, because like I told you, I just finished working on a distributorship agreement. One of the sticky points we had in that distributorship was how we would structure our distributorship to not infringe on the FCCPC Act. So I know, for instance, that we are trying to have an engagement with the FCCPC, that's the Federal Competition and Consumer Protection Commission, to actually discuss this issue and say, look, what is the fate of franchising business with your act? Are you going to create a special exemption and put a regulation that now allows franchises to go on and, in a way, be a derogation from your act? So that discussion is ongoing. A second government agency that also impacts on franchising is NOTAP. That's the Nigerian Office for Technology Acquisition and Promotion. So part of what they do is to regulate technology transfer. So a franchising also usually has elements of technology transfer. So therefore, because of that, it has to go through clearance of the NOTAP. And NOTAP is becoming a little bit more aggressive now and ensuring that in your franchising, you are indeed passing on skills to Nigerian workers, that the Nigerian workers who work with you are able to, at the end of the franchising, be able to come into those, there should be a proper technology transfer where they come to know. So because of that, I believe it was group 3 who talked about trade secrets. So because of that, there's an ongoing argument. In the franchising deal now, you have to review some of your trade secrets. Of course, if you do that, then there has to be an agreement in place that governs how those trade secrets will be used by the franchisee. So it's quite a thorny area, and it's something we need to look at. So thank you. I believe I've shot over my time so much. So thank you. And of course, the next mentor, who is my big madam, is also around. So I'm also eagerly waiting to hear from her. Thank you.
Thank you very much, Mr. Max. Thank you very much. Mrs. Victoria, are you still on the call? Mrs. Victoria.
Sorry, I believe Ms. Victoria has dropped off. She wasn't feeling too fine, I believe, and she spoke earlier, so she has likely covered her own part before dropping off.
All right. Mrs. Shukurat. Is Mrs. Shukurat still on the call?
Okay, can you hear me?
Yes. Hi,
everyone. I can see you. I just sent a message. So, so I believe Mr. Max has done a good job. So I'll just be speaking on some aspects. So I think we should look at the first thing is, why do you want to protect your intellectual property? You have to know your why before you know what exactly you want to do. Because some people are like, I'm just doing this work, like I just want people to benefit from it, not because I want to gain anything from it. So your why is very important. Why are you doing this? And that's the reason why you will see some people are not chasing after people. They're not after infringers. But some people are like, no, I'm after infringers like this. You cannot use my work. But some people are like, it's free for everybody, let them use it. So you have to know the reason why you are doing it. So once you know your why, then you know, okay, fine, this is what I want to do now. Which right do I have? if you are using patents, what right does patent give you? What right does trademark give you? What right does copyright give you? What right does industrial design give you? And you have to know which one works for your business. For example, if you are doing, for like Coca-Cola now, let's assume Coca-Cola actually patented their trade secrets. What do you think will happen now? The secrets will be out. So you have to know which one works. What kind of business do you do? Do you think it's a business that will take a very long time? Or do you think it will take just a very short time? So if Coca-Cola was doing something that is very short term, probably the patents would have worked for them. Then during that 20 years, they will maximize the opportunity. And after 20 years, the secret is out. Because they're looking at a long-term goal in the market, they went for trade secrets. It is after 100 years, they are still protecting that trade secret. So you have to know which one works best for you. I think I was still discussing with Mr. Marks on the copyright for Mickey Mouse, right? You know, they have copyright and they've been extending. Whenever it's time for that copyright to expire, you just see the United, they just change the Copyright Act to increase it for 95 years now. So by next year, that 95 years is going to complete their protection term. And I was like, it was like, I'm sure they will come about something else and increase it again. Do you understand? But even if that copyright expires, they still have trademark as backup. Do you understand? And trademarks is like, once you keep renewing and managing it, you can do it like indefinitely. So once the copyright expires, they can still fall back to their trademark. You can still use it. They have about 99 trademarks, if I'm not mistaken. So when one is going, another one is still in line that is keeping it up. So for example, we were talking about patents. Yes, they all have criteria. But you can't just wake up one day and say, I want to trademark, or I want to patent, or I want to. It has to follow the criteria. For example, if it's trademark now, it has to be distinctive and not deceptive. We were saying it the other time. You can't be selling Apple and want to trademark Apple. It doesn't work that way. Your product should not be distinctive, should not be descriptive of what you are selling. It should be distinctive. And it should not violate public morality. You can't be selling wine and alcohol and you have an image of an imam or pastor. No, that's violating public morality. Then it should not be deceptive. Don't say you are selling raw leather when you are selling fake leather. No, you can't do that. Then the aspect of the generic side, it can be generic. You can't say you're selling furniture, I want to trademark furniture. So how about those that are selling furniture? You want to send them out of the market. So your trademark should not be generic. It should not be descriptive. It should be distinctive and not deceptive. So it falls about distinctiveness. So when something is distinctive, it means it's not generic, it's not descriptive, it's not deceptive, and it's not violating public morality. So that's for trademark. So once you tick all those boxes, then you are good to go to do your trademark. You can now do your search. And your trademark search is very important. For all intellectual property, you have to do search. Make sure before you enter the market, somebody is not already using that name, so that you won't come back and say, oh, I've done marketing and this mark is already taken. You have to do your search. It's very important. But when it comes to copyright, you know, copyright is like automatic, right? Copyright is automatic, right? But even for you to have that copyright protection, it has to be original. That originality has to be there. And when you say original, it means this thing you have put and your creativity is new. Even if it's something that is already existing, whatever it is you are adding is kind of new to whatever it is you are doing. It should not be as if you are changing color white to color black. That's not creative enough for me. And I think that's why we still have an issue on transformative copyright usage. How will you just say you are changing the color to color black and you're saying it's transformative? How is that transformative? So copyright has its own wahala on one side, but we should also understand the other aspects. Because I can see people these days, people are now trying to like infringe knowingly and saying it's fair use. You get, they are infringing knowingly, but they'll tell you no, it's fair use, it's fair use. I'm not getting money, I'm not, and it's a lie, you understand? So that copyright we still have to put it to one side, but just understand that whatever it is you are doing has to be original. There's this, you see different, I think Burna Boy and Odogu, they were talking about the Odogu issue. Even if you want to trademark Odogu, do you think it will pass? I think the Igbos are more used to calling themselves Odogu, but do you think Burna Boy claiming that name Odogu will pass? And even Obi Kunobana that is saying is Odogu, who will they now give? So you have to like know what exactly it is you are doing. Assuming he has spoken with a trademark person, they would have advised him that you can't actually have ownership to this mark. Probably would have changed it to something else that will work for him. You get? So I think they are still on that. So copyright is mainly originality. Just make sure what you are doing is original. Even if you are using somebody's work, ask for permission. That's another thing. Permission is very important. The moment you don't ask for permission and your song blows, they are coming back for you. Big time. And most of what we don't know is that you feel like I'm just singing, they can use it. But the time that song blows, they're coming back, they're not giving you for free. So whenever they tell you you can use it for free, tell them, I want an agreement. What exactly are you taking? Because when the song blows, they will come back and say, no, I'm no more doing this for free. It's not for the society again. It's not my own. I want my money. So you have to put all those things down because people don't know when they will blow. That's the major thing. They don't know when the song will blow. Like I asked someone that was telling me, okay, there's this other producer, he begged him to use his music. Now they've used the music because the song has blown. He's coming back and asking for different percentage every time, and he's tired. He doesn't know what else to do. So in the first place, the song might not blow, but once the song blows, they're coming back to ask for their share. So know what exactly you are doing. Are you doing it for the society or you are doing it to make money? So have that agreement. Then for patents, I think Mr. Max has said it already, it has to be new. That's novelty. Then when we say new, it doesn't mean it has to be bringing engine and engine together or anion and cations. Even just something small can be new. It could be an improvement of what we have already. An example is the big biro. You know, before we used to carry ink up and down and use feather, put feather just to write. But when the big biros, the big brothers come together, then they okay, let's do this in a way that it will be seamless for people to write. Then they created the big biro. So we all call it big biro, but it's actually a ballpoint pen. The name of the brothers, we have two brothers, Big and Biro. So big biro. But we're not calling everything, I want to buy biro, I want to buy biro. Do you want to buy the inventor? So that's another thing about generic name. So big biro now has now become generic. But if you want to buy biro, I said biro tonight, you see? You want to buy a ballpoint pen, you say you want to buy biro. So that's generic mark. It's now generic. So try to avoid your mark being generic. We have Indomie, we have Milo. I want to buy Milo. Even if it's more that they give you, you collect it. But it's Milo you said you want to buy. You want to buy Pampers. Which Pampers? Is it Moflix? Is it this? Is that? They are all generic. So try to avoid your mark from becoming generic. So that's on the trademark side. Then, okay, for us on patents, I said newness has to be new. It has to have an inventive step. Inventive step with the fact that I should not be able to say A and B together and get Z. No. Somebody skilled in the act should be able to like look at your patent, go through it very well before they can say this is your answer. It's not just I will just come from nowhere and say, okay, because I'm an engineer, I know this and that. When I put A plus B, I get my answer. That's not inventive. Your work has to be inventive before you can qualify for patent application. Then it has to be industrially applicable in the sense that it has to be mass produced. Why would the government give you 20 years protection and they can't even mass produce whatever it is you are doing? It doesn't help the society. Because this thing is give and take. Government is giving you protection. You are giving them your invention. So if they're not getting anything from you, why should they give you that protection? So that's why you have to disclose it, because they're not okay and you are protecting it for 20 years. Once that 20 years expires, we are releasing it. Let people use it. Mass produce it. Make society better. But if they're giving you 20 years to protect your invention and your invention cannot be mass produced, doesn't have an inventive step, and it's not new, who is gaining? Nobody. So it has to be trade by barter. You give me something, I give you something. So it's not about the money. Even the government knows that they can make money from the protection. That's why they have to make sure that this thing, when it comes to enforcement, to make sure that people are not using it because they know what they're gaining from it. You are improving the society to the government. They are collecting tax from whatever you are doing. So it's not for free. So you have to know what exactly it is you are doing. Then for industrial design, it's just like patents. They call it design patent abroad, but we call it industrial design here. So it has to be new as well. It's just that it's less stringent compared to patents. It doesn't have that inventive step aspect because it's all about aesthetics. So it's just the functionality, but patent is technicality. That's just the difference between industrial design and patent. So another thing I'll talk about is overlap, intellectual property overlap. Most times we just go for one IP right when you can have the 4. Why do one when you can have 4? So like I said, if Disney didn't actually have copyright and trademark, when their copyright expires, there's nothing to fall back on. But now they can fall back on their trademark because they have trademark rights. So you can do trademark and industrial design. For example, when you say industrial design is aesthetics, you know industrial design can protect the Coca-Cola bottle. However, your trademark can protect the 3D design. So why would you want to do industrial design that will last for 15 years when you can do trademark that will last indefinitely? You have to wait, which one is better for my business? Should I do trademark or should I do industrial design? if I'm doing industrial design, this design, do I plan on improving it in the next 15 years? Okay, fine, let me do industrial design. But this design, I don't think I want to change it. Let me do trademark to protect the design. So that's what Coca-Cola always check and balance. Like, should I do industrial design? Should I do patents? Should I do trade secrets? Another one is copyright and industrial design. For the fashion industry, most times, should they do copyright or should they do industrial design? Copyright should protect the sketch of your fashion artwork, fashion work. But when it comes to industrial design, it will protect the outlook of that design. So which one should you do? Should you do copyright or should you do industrial design? Or should you do both? So you have to like balance it. Which one am I doing? So you won't give yourself, you won't give that to say that gap for someone to come and infringe. So you have to take the one that actually work better for your business. So I think when it comes to IP and business, it's majorly patent and trademark majorly. So when you are doing your trademark, you have to know that there are classes to trademark under. Like, don't go and be doing trademark for business that is entertainment business and you're trademarking under legal rights. Like, who does that? So you are not doing anything. There's no protection for you. If you're under entertainment, make sure you're doing your trademark under entertainment. If it's legal, do it under legal. If it's hospitality, do it under hospitality. You can even do it under different classes if you wish to expand to those kind of classes. But make sure you are picking the right class. We have 45 classes. 1 to 34 is for goods. 35 to 45 is for services. So if you are doing any services, look at the class from 35 to 45. If you like the trademark class, can send me a message. I'll send you the list of the trademark classes. So each class, you know, you are trademarking under one particular class. Or if you have more business that is doing the same line, you can trademark under those particular classes. But don't trademark in a class that doesn't benefit you. Because when infringement comes, you can't lay claim to it. And another thing is people feel like when I trademark, I have rights over all. No. If you have a trademark, I'm assuming you have a trademark Apple and you are selling electronics, somebody that is doing hospitality can have that trademark to Apple. Your protection is limited to the kind of business or the kind of class you are trademarked in. So we have to know that. We don't say because you trademark a particular mark, anybody cannot use it. No. Anybody within that same line of business with you cannot use it. But somebody else outside that line of business can still use it. Just like we have the Dove soap and Dove chocolate. So you have to know which one exactly. So if you feel like you still want to venture into other type of businesses, then protect it in those classes as well. It's just going to cost you money. But if you know the value of your trademark, you won't mind. So I think that's Mr. Ongamax. What else did I miss out?
You covered it all. Well done.
Thank you.
Thank you very much, Mrs. Shukra. That was really wonderful. I learned quite a lot. So it is picture time, everyone. So everyone should put their videos on. Everybody should please put their videos on. We want to see your faces.
I have a question, kind of a question.
Okay.
Yes. Recently, this issue that came up between Sabinus, Investor Sabinus, and
why is it not working? The video part. The video.
So recently,
I want to show them my face.
Now we are past the Sabinus issue. Are we still on it? We've had like several classes on Sabinus issues already. Sabinus issue already.
You mentioned something about patent in a particular class.
Okay.
I'm asking myself that Sabinus stuff, hand stuff, that hand design is to do for himself. It's not under under entertainment, but it was used for food. Gala is food, and people is under food. So how did he have a right, a claim, since it's under entertainment, and people can Gala is under food and nutrition? Since if
so I think the Sabinus issue are into two cases. It has one with Gala, and it has one with what's the other one now?
Peak milk.
Peak milk now. So the one with peak milk is the something uj wala. So that's something uj, number one. Peak milk is into food, right? But Sabinus is into entertainment. But when he did his trademark registration, he did it under finance. How does that correlate? So that was the more reason why he can't even sue them, because they are not, he didn't protect it in that class. He protected it under finance class 36. Is it because they are calling you investor Sabinus? You not say, okay, you're an investor, you did finance, and you left the main entertainment, you left it out. So that was the mistake he did. And again, he doesn't have a certificate. Without your certificate, you actually don't, you can't sue somebody without a certificate. So your certificate has to be out before you can sue. Your acceptance letter does not equate certificate. It only gives you like, okay, fine, you can do business with it, but you can't sue with your acceptance letter until you have your trademark certificate. So that's another issue. Now the third issue he has is something huge. Like everybody have used something huge. It's not generic already. Like what's special about something huge?
The way he dressed, he stressed the huge.
Okay, so that's about the trademark now. But now for the copyright, this is post now. It's something he can copyright. Like he can have the sketch copyrighted under copyright. So that's just one thing that he can actually have a right on that one. But for that trademark issue, he really doesn't have so much right. But for the copyright on his post, he has a right on that, because everybody knows. Even if they change the color to indigo, violent, you know it's still Sabinus. So he has a right to that one. Yes.
Thank you very much, ma'am.
You're welcome. Okay, I think we have somebody else.
Ma. Okay. Good evening, Ma. I have a question. You said something about try to avoid your mark from becoming generic, and then you made reference to Indomie and I guess Beak. You said something about that. I want to know, how do you avoid your mark from becoming generic? I mean, it's not like people love, okay, like now you said Indomie. Now, if people say Indomie more instead of noodles, how do you make them stop saying Indomie? I mean,
you can start by doing advertisement. You can use your advert to say, we are Indomie noodles, or we are not Indomie, we are not the same as Mimi. Or just try to differentiate yourself in the marketplace. There are different ways. You can use kits, you can use something else, but just make sure you are trying to distinguish your brand, because that's what your trademark is meant to do. Once your trademark is no longer distinguishing your brand from that of others, then it's no more a trademark. It has to identify your products and distinguish it from that of others. But once it's not doing that, it's no longer a trademark.
Let me just add to that. One way to do it, you see some adverts where they say Indomie is a brand of noodles. So you state it clearly, make it clear that. And then when you write the Indomie, so for instance, I just did a brand guide for a distributor company now. Whenever we write the word Indomie, my client's brand, for instance, it was Indomie now, we make it clear to them, always capitalize the I. So everybody still understand that this is a noun. This is not a general word. So if you make it clear that this is always a brand name, it is not a generic name for goods or services of this nature. So we make it clear to them in putting up our adverts on your website, on social media, putting up a signboard in front of your shop, always specify under a brand of so and so and so type of product, just to avoid that happening. So what will happen is that if you go to court and the person says, look, your brand has become generic, you show evidence that, look, in all our advertising, in all our letters, because we always make it clear to them, do not use our brand as a generic term. So that would persuade the court that this is not
because
generic.
another disadvantage is because if the other brand commits something, like something suicidal or something infringing, they'll tell me to your brand first before you can now say, no, it's not my brand, though. You now start giving them reasons, showing proof that it's not our brand. So try to like differentiate your brand from other brands.
Thank you, ma. Thank you. Thank you very much.
Very much, ma.
Okay.
So
I think somebody else asked a question, but she's muted. You need to unmute yourself, Udo.
Yeah.
Yeah. Good evening, ma. I can hear you. Good evening, ma.
Good evening.
Ma. Thank you very much. I really enjoyed your session. So I have a question. When you were giving your talk, you said something about search, going in search of knowing if any other brand has the same brand name with your product or your business that you established. And I know there's this thing that lawyers call due diligence. Like, I don't know if it's the same thing. And then is there a particular website, or do we just go on Google and type the name of the product and hope all the people that are most likely have interest in that particular name, you know, are just...
Okay, so this is what I will say. Nigerians, we are kind of stingy with information, so we don't like to put out information.
Yes.
So the thing is, you know, on assuming it's CSC website, it's easier for you to just go and search your name, but it's not the same with the trademark website. Like you don't have that opportunity to search. Like you have to go through a trademark agent, because all the data application or the data, they are under the FMIT database. So it's not available for you to search unless you have an agent that can search for you or an in-house person. So you have to like tell someone to do the search for you, and you have to pay. You have to pay for search. So don't just assume that you've said Google. Nigeria database is not out, so you won't find anything close. You won't. So don't just go and put your client in one kind of situation.
So let's move on.
Actually, let me just quickly add to that. Search actually is a subset of due diligence. So due diligence is a multiple aspect, and it has a lot of other aspects to due diligence. So there's also, for instance, what we call freedom to operate. So freedom to operate is a type of due diligence where you are like letting a person know what could be the possible things that would impact, extending that brand into a particular territory. What are the existing IP rights that are already there? Which of them have become generic? Which ones have lapsed? And also, a search is just the rudimentary. That's just the first level. But what a search does for you is to know what is existing. So, and I always advise people that search involves multiple databases. So, for instance, if you want to register a trademark, you have to search, do a search, pay and do a search at the trademark registry. But in addition, I advise people go to CAC, the Corporate Affairs Commission, also do a search there. Then, of course, you could use Google as an additional source. And then there are other specialized databases like the World Intellectual Property has a specialized database as well that you could also search. But it's not, so some people do, so for some people, that's a whole business model. Just doing due diligence and search for people alone is a huge business for
Thank you, Mr. Marks. Let's move on to the questions sent by the groups. So, Mr. Marks, question number 1, does a person's citizenship affect their ability to get protection for the intellectual property?
Okay, so I'll give a quick answer like a lawyer, yes and no. Yes, from the viewpoint that, or no, no from the viewpoint, first of all, that anybody who fulfills the requirements to register an IP right in Nigeria automatically gets an IP right. So even if you're a foreigner, you fulfill the requirements, you can get an IP right, whether you're based in Nigeria or outside of Nigeria. But no, or yes, from the viewpoint that if you are, for instance, not a member of certain international treaties, you cannot take advantage of certain expedited processes to get IP right in many countries at the same time. So for instance, as a Nigerian, Nigeria is a member of the Madrid Protocol. So if I have a client who briefs me and wants to do a trademark and wants the trademark to extend beyond Nigeria and also register that trademark in other countries, what I do for them is to register a company for them. Maybe I used to use Ghana before, but lately Ghana has been troublesome. So sometimes I just register a company for them in the UK. UK is easy because I can sit in my office here in Abuja, register the company in the UK, register the trademark in the UK. And because UK is a member of the Madrid Protocol, I can now use UK to get them to register that trademark in potentially close to 100 countries around the world. So you could see that your citizenship in that case now matters, because as a Nigerian citizen, you will not be allowed to use the Madrid Protocol because Nigeria is not a member of Madrid system. So you need to now have a company registered in the UK, even though of course there are some technicalities around it. So you need to have a distributor on ground in the UK, otherwise your mark would no longer be valid for non-use in the UK. So it can be a technical issue. But like I said, yes or no, but it's always good to be a citizen of a country that is complying with international obligations.
Okay, so to question number 2, Mr. Max. Oh, sorry, Mrs. Shukra.
Okay.
What precautions can a franchisor or a licensor take to prevent exploitation of their intellectual property?
Okay, I think the first thing is you have to protect it. Okay, there was this case study. Okay, we saw one. They said there's one Amalaskai. The Amalaskai in Ibadan is now in Lagos, and we're like, do they have a trademark? You don't have a trademark, and you're licensing, you're franchising. Like, what kind of business is that? Before you can even license or franchise, you have to like make sure your IP rights are intact. Your trade, even when you don't need, do it, because the day you will need it, you won't know. So before you even want to license or franchise, you have to like make sure you have all your IP rights intact. If it's trademark, have it. If it's copyright, if it's patent, do all of that. But it now depends on whatever it is you are doing. Are you doing exclusive licensing? Are you doing non-exclusive? Are you doing, it depends on what you are doing, because you have advantage and disadvantage to all of these things. So you have to just do your due diligence, know which one works best for you. Is it of your advantage or more of your franchisor or your franchising? So just make sure your IP right and intact. Once your IP right and intact, nobody can come behind you and use it. But once it's not intact, then you have a problem.
Thank you. So to question 3, back to Mr. Max. How is the IP valuation done? Does it have a laid down process to achieve it? Mr. Max.
Thanks for that question. So yeah, an IP valuation actually is an economic function. So it's essentially a function of putting a value. So one of the first steps involves, of course, is what we call an IP audit. So an IP audit means, first of all, let us even check what are all the IPs we have, which is protected, which is not protected, which is about to expire, which has not expired, which has become generic, which has fallen into a public domain. You need to understand all of your IP, first of all, what IP you have. Then the valuation itself, like I said, is just an economic function of now, and there are different models to IP valuation. So there's a model that says, what is the potential income that this IP can fetch us? So for that, you use what we call the discounted cash flow method. Now there are other functions where you are looking at what is the cost of, if we lose this IP, what do we stand to, or what will it take for us to be able to benefit from the IP, assuming we to reinstate our benefits from that IP. So there are different models, but they are all just economic models that try to give a fair idea of what your business is benefiting from owning that IP. So it's used in many contexts. Once, if there's already litigation, you want to give the judge an idea of how much damages you want to claim for the infringement. You need an IP valuation to say, okay, how valuable is this IP, and how valuable and how much has this infringement impacted on the value? Then that becomes the cost of what the court would award to you as damages for that valuation. So valuation has it doesn't have strict laid down procedure, in that it's flexible, but essentially there are international best practices around valuation. So if you do something that's outside of that best practice, by the time you go before a judge or an arbitrator, they'll say, look, we understand what you're trying to do, but you have not followed followed international best practices, so we'll not be able to award you beyond what international best practices would dictate. So in a sense, yes, there's some level of process to how it must be done. Thank you.
All right, to the next question. Are service marks the same as process patents? Mrs. Shukra, please answer that for us.
No, we can't say service marks are the same as patent process, because when you say service marks, it means marks that are showing that these are services, just like we have class 35 to 45 for service products. But it doesn't mean they are not trademarks. They are trademarks. We have service mark, we have certification mark, we have what's that other one, Mr. Marks? Collective mark for society. What do you call it?
Yeah, collective marks.
We have collective mark, we have certification mark, we have service mark, but they are all trademarks. Because when you register your mark, they won't give you a certificate saying service mark. It's all trademark. So service mark is just like saying this mark is offering services, but it is still a trademark. It's not the same thing as process patents. And when I say process patent, talk majorly about the method patents under utility and the other patents. Yeah, not service marks. Service mark is the same thing as trademark. It's just as saying this one is offering services, but it's still trademark.
Okay, thank you very much. Due to our time, we'll be calling it a day here. Thank you to everyone that stuck with us till now. We'll be treating the other questions in the next session. Hopefully, the other mentors will be answering the questions for us. So thank you very much. It has been a really wonderful time. I don't know about you guys, but I really learned a lot. So thank you very much.
Thank you so much. Thank you so much, Kiki, for moderating. Thank you, Shukura. Thank you, Mr. Max. Thank you so much for your time. And I'm so impressed by all the mentees. Like, you people put your videos on, seeing the presentations, everything. Like, the research that went into this was just amazing. The cooperation in the group. To even think that this is week 1 and you people are so coordinated, so on point. I'm telling you, energized, and then the videos. We didn't even have to beg you guys to put your videos on. Your videos are on. Amazing. And it's so good to see Mr. Max. Thank you so much. We love you. Thank you for your time. Thank you for everything. Thank you, Amosa. Thank you so much, Amosa. Amosa is so knowledgeable and she brings so much energy. Please, if you want to know more about IP, kindly follow her because you would actually see a lot of practical things to what we do in IP. And then to Victoria too, she wasn't feeling fine, so she had to log out. So thank you, Kiki. Thank you, Hussein. Thank you, everyone. You people are amazing, amazing people. Sorry, I'm on the road, so that's why my video has been off since. So with that, we'll be rounding up for today. Have an amazing weekend, everyone, and we'll be seeing ourselves next week, Friday. Thank you. Follow Amosa on the Intangible Nuggets. Yes, follow Mr. Max. Also, follow Victoria. And don't forget to post your pictures, write what you learned on LinkedIn and tag them. That is one way to say thank you for their sacrifice today. Thank you so much. Love you all. Bye.
Bye.
Thank you so much. Bye.
Thank you.
Thank you.
Thank
Thank
you.
you. Thank you to the panelists.
You're welcome.
Okay, thank you, everyone. Thank you very much. Don't end. Close. Homicide.